then the other impact. So Vivekananda Mandir Vidyalaya case, we all know that crucial date, 28th February 2019, where the Supreme Court pronounced the judgment holding many of the allowances as part of wages for the purpose of PF. Right. Of course, typically, crucial point is that the managements were not able to prove that those payments were only allowances. Right. So that is the reason they finally decided that that would be treated as part of wages. Right. But the principle laid down in that particular judgment, that will continue to be there. So that will not change. Again, I would say that there is no new principle that was laid in that case, but instead they were re-emphasizing on the principle laid in the bridge and roof case, maybe as early in 1963, right, where some amount is universally necessary and ordinarily paid, that would be treated as wages or basic wages, right? So other payments, only if it happens to be a contingent payment, only if it happens to be a conditional payment, that alone will be treated as allowance. So that alone will qualify for exemption for the purpose of PF, right? So otherwise, other payments will be treated as part of wages, and that is to be reckoned for doing PF contributions. That was the judgment pronouncement in that case. I think that will remain. So there will not be any change as with respect to that particular case, because this will have major impact on the PF contributions. That is the reason, in fact, I just thought to explain whether there would be any change with respect to this particular pronouncement. And secondly, another landmark judgment, air freight judgment, we all know, again, somewhere in 1997. So the Supreme Court said very clearly, after excluding the components which are very specifically mentioned in the exclusion part under the Payment of Minimum Wages Act, the remaining portion, if it works out to maybe equivalent to or more than the minimum rates of wages, then that is considered as treated as sufficient compliance. Same principle that will continue to apply. There will not be any change as far as this principle also is concerned. Right now, HRA is not part of wages. So excluding HRA, the remaining portion, and excluding other parts which are to be excluded, which are there in the new definition. The other parts, if it works out to more than minimum wages or at least equivalent to minimum wages, then that is considered as sufficient compliance. So there is no change in that principle also. Then we come to Madras Fertilizers case, where I think the Madras High Court said that gratuity would be treated as part of wages, right? But again, this position will definitely change, because in the new definition of the term wages, gratuity is very clearly excluded, right? Earlier, if we go through the definition of the term wages as defined in the Payment of Wages Act, there is some portion which was mentioned in the inclusion part, and there was some portion which was mentioned in the exclusion part also, right? So based on the one which is there in the inclusion part, Madras High Court gave a judgment holding gratuity to be part of wages. That is the reason for the establishment situated in Tamil Nadu, because the Madras High Court judgment is binding on all the establishments situated in the state, right? So even if the contractor fails to pay the gratuity, the liability passes on to the principal employer. As on today, I am saying, because of this judgment. But there are contrary judgments by other high courts. So I think this will not have universal application, right? So this particular judgment of the Madras High Court given under Madras Fertilizers case, this will automatically get nullified, right? This will no more be valid. And reduction in salary for PF and other areas. We all know that there is a section 12 under the current Employees Provident Fund and Miscellaneous Provisions Act. The employers are not supposed to reduce the salary of an individual in order to, or with a view to, reduce the contribution towards PF, right? So that is not possible. But not only for PF, ESA also the same situation, right? But the same thing will continue. Same thing will continue. So with an intention to reduce the quantum to payment contribution towards PF, the employer cannot reduce the salary. But because of the change in definition, if the quantum is reduced, then I think employer is at no fault. So there will be no change in the principle. Same thing will continue. And secondly, some of the maybe experts or professionals, they were asking me, in fact, whether we can reduce the making contributions to the statutory ceiling of 15,000, since they are already doing the contribution on the actual amount which goes beyond 15,000. That can be done. Even today, that can be done. Even after the implementation of codes, that can be done because that is legally valid. There is a judgment by the Bombay High Court as well as by Kerala High Court, right? With respect to Bombay High Court, it is Marathwada Gramin Bank case. With respect to Kerala High Court, it is the R. Vijayan's case. Both the cases, it deal with that particular issue. They very clearly say reduction of contributions to the statutory ceiling instead of the actual salary will not be considered as reduction as referred to in section 12 of the PF Act. That is what they are saying. So if some of the companies who are making the PF contributions on the actual wages, if they want to reduce, if you want to reduce it to restrict it to the salary ceiling of 15,000, that can be done. That is possible, right? Then HRA, again, HRA is currently part of wages, particularly with respect to Minimum Wages Act. So even if mere minimum rates of wages are paid, particularly this can happen with respect to the contract workers. Assume that 10,000 is the minimum rates of wages. The employers have the tendency of splitting it into basic and HRA. So 7,000 basic and 3,000 HRA. That is okay now for the purpose of Minimum Wages Act, right? But HRA is no more wages as per the new definition. So once the code gets implemented, this cannot be done. So the position is slightly getting changed. And with respect to gratuity, it will not be treated as wages because clearly it is excluded from the definition of the term wages under the new definition. I think we discussed on Madras Fertilizers case. Same thing almost. I move on.